let's get into it right now with Hassan versus Orbiters. Okay. So let's show you guys the PP, right? I'm going to whip out my PP here, guys. And by the way, make sure you smash the like button, regardless of how you feel about the PP. Make sure you smash the like button. It's very, very important. And also consider sharing this out on social media because it'll help us get going here as we race towards 2,000 subs. So we're in a continuation of Klein versus the Orbiters. As you guys all know, Ethan Klein is still engaged in a copyright infringement lawsuit, not defamation, not defamation, not criminal, whatever. This is a copyright infringement lawsuit against Casey Trons, Denim, and Frogan. Now we're not going to talk about Frogi Yogi because Frogi Yogi got a delay of game, and Frogi Yogi has a different lawyer. So these two ladies have the same lawyer, which is going to be a potential conflict. So as this thing goes forward, this is going to be a conflict of interest, without a doubt, between Casey Tron and Denim's having the same attorney, because they can make adverse statements against each other. So that's potentially problematic, right? And particularly if they come into a settlement arrangement, right? The settlement for one could involve selling out the other. So I think their lawyer has a conflict, but somehow magically that lawyer agreed to this, and both of these girls agreed to this, which is very, very insane that this happened. So these two girls have answered the complaint, which means they received the initial legal paperwork and they wrote back. They said, here's how we respond. And what I want you to understand when we look at this, their defense, is that Denim's filed her answer on the 14th and Casey Tron filed on the 15th. So this is something that happened just a couple of days ago, right? So it's very fresh legally. Almost nobody has covered this. Certainly people haven't read it in detail. And what I did was I read the entire document, both of them, and I looked at what they had in common, and I wanted to present the defenses they have in common. Now, just so you understand, an answer has two things. It has a section which talks about the paragraphs in the complaint, and they go paragraph by paragraph, and they say, we agree with this paragraph, we disagree with this paragraph, or we don't have enough knowledge to agree or disagree, and we cannot say, right? Or it's a legal conclusion, and we cannot say because it's a legal conclusion. So that part, the part that talks about whether they agree, disagree, or whether they don't know about the entire complaint, which is very long, and they go paragraph by paragraph, that part is boring as hell. And to read through that is like reading paint drying. So we're not going to do that. What we're going to talk about is the second part of the answer, where they go into what's called affirmative defenses. So these are the defenses that they are raising to Ethan Klein's lawsuit. And an affirmative defense means even if Ethan Klein is right, I'm going to get away with it because X. So we're going to score all of those. I'm going to explain to you the law. I'm going to explain to you what each of those defenses is, what Denim's is saying and what Casey Tron is saying. I'm going to explain to you which one it is. We're going to score them, and I'm going to tell you whether there is hope or whether there is cope with every single one. And I'm going to be very fair and objective, but I got to say, overall, you guys know this, and I've said this before, it is not in the favor of Denim's and Casey Tron. It does not look good. But I'm going to tell you one by one, is it hope or is it cope? So let's get into it. And so typically the specific responses are very generic, mostly non-committal denials, but the affirmative defenses are interesting. So we're going to focus on what's interesting, because I don't like doing boring. And I'll show you, for example, this is the Denim's complaint, right? I'll show you what I mean by boring. And I'm going to talk about this in kind of the fast facts versions and the other stuff. But you kind of see right here in the document, here's the beginning of the document of the answer, Alexander Marwer Saber, aka Denim's. And then they go line by line, paragraph by paragraph, saying paragraph 1 contains legal conclusions to which no response is required. Defendant denies the allegations in paragraph 2. Paragraph 3, defendant lacks sufficient knowledge. Paragraph 4, defendant denies, legal conclusions, lacks knowledge, admits. So once again, in 10, they admit that. So you'd have to go back there and say, okay, what did they say? By the way, usually the only thing they admit is their name and where they live. Typically, that's it. Typically, they don't admit anything else other than their name. And that's all. That's what they'll agree to. Yeah. So what we're going to go through is not this part about admitting or denying, because that's kind of boring. What we're going to scroll down is all these affirmative defenses, which are down here. So failure to state a claim, fair use doctrine, express license, implied license, unclean hands, waiver, estoppel, justification and excuse, consent, innocent infringement, no injury and damages, good faith, inequitable conduct, unjust enrichment, Laches, failure to register copyright, lack of notice, reservation of additional damages. So we're going to talk more. The reservation we're not going to talk about because that's kind of a catch-all. But all the rest of them, we're going to go through and I'm going to score those. And for some of these, ladies and gentlemen, for some of these defenses, I genuinely believe their lawyer may have been high. I'm not kidding. I don't know what the legality of marijuana is in the state in which they're practicing, but I do think that their lawyer could have been ingesting cannabis at that time. Now, I'm not saying it's negligent, but I'm saying it's very creative, if you know what I'm saying. If you know what I'm saying. I looked at that, and I actually had to look up some of the defenses because they just pulled them out of nowhere. And literally, there are certain defenses they use that aren't even real in this area of law. I'm going to say that again, because I think you need to process this. Some of these defenses don't even exist for copyright infringement. It's as if this lawyer doesn't have a lot of experience in copyright infringement, or he wants to try some crazy stuff. And he's just throwing spaghetti at the wall and he sees what sticks. I'm not saying he's committing malpractice or he's not competent. I'm just saying it's very creative. We're going to use that word. We're going to use that word. Very creative. That's all. So let's get into the key accusation. Oh, this is the wrong one. Boop. Let me continue to go. First, failure to state a claim. Okay. So this is the first of the affirmative defenses. So the first affirmative defense is failure to state a claim. What failure to state a claim is it says, even if all the facts are true, in a complaint, they do not establish a valid legal cause of action. This is saying they're going to be able to remove this on a motion to dismiss. Are they going to be able to argue that there is no claim here? This is an extremely weak argument. Yes, you can make the argument. It's not an impermissible or impossible argument, but it's extremely weak, and the likelihood of success is cope. The likelihood of success is cope for the affirmative defense of failure to state a claim. The motion to dismiss will 100% be denied. There's no way they're going to win on motion to dismiss. It's just not going to happen. Next is fair use. Now, this is their strongest of all defenses, and I give it a 5 out of 10, which is the most I'm going to give for any of the affirmative defenses. So if accused, copyright infringement, use of the copyrighted material falls under the fair use exception and is therefore not infringement. This is a 5 out of 10. It is a toss-up, but the odds are in Incline's favor. So I would say, if you really had to say, okay, in terms of arguments, because my strength of argument means, is this a killer argument? Is it like totally a winner? And did they make it persuasively or did they not? I think it's a toss-up. They've got some facts that they may be able to argue, some case precedent they may be able to argue. So that's why I give them a 5. I'm trying to be very generous. I'm trying not to be unfair here. For affirmative defenses, this is the one where they need to spend the most time. Everything else is not as strong as this. They have one other, which maybe you could argue, but it's not as strong as fair use. It's not as strong as fair use. So I think it's a toss-up in Incline's favor. Okay, next, express license. What this means is, did Ethan Klein give Casey Tron and Denham's permission expressly to write it. So a plaintiff cannot claim infringement against a defendant who uses plaintiff's copyrighted work if the plaintiff granted the defendant an express license to use the work. So if you said, you can use this, it's okay, you can copy this, then you've got no express license, especially if you put that in writing. You put that in writing. I think this is a weak argument because there is no, and the likelihood of success is unlikely because there's no written or specific license. There's nowhere where there is a written or specific license to use this content. Now, there's implied license. This is different. This is different. This is a little bit better. This is the second best defense in everything. The second best defense. Not perfect, but the second best. So you could argue about permission. And once again, the defense is permission to use something copyrighted material, to use some copyrighted material that is not explicitly granted, but it's inferred from the conduct of the owner or the circumstances. So this is a very generous ranking. A very generous ranking. Once again, I'm trying to be fair and professional, and I'm trying not to be biased here. So I'm trying to be very generous. Ethan Klein did at some point make a general statement about how he treats people using his content. However, he did not say, I give you permission to take the entire video with minimal content. And he also did not say, I give you permission to maliciously redirect traffic. So I think it's going to be difficult to argue that. However, it is easier to argue implied license than it is to argue express license. So this might be more possible. Once again, I give this at best, a 30 or 40% shot. And that would be me being very, very, very generous. Me being very generous for a 30 or 4% shot. Versus it's a toss-up, maybe like a 45% chance on fair use because you never really know which way it goes. I think 65% in favor of Ethan, 45% on the other way because you really never know. This one's more like 20, 30%. Right? Much slower. Yeah, he definitely. So an express license means in writing. He never gave them writing or an email or something like that. Implied means the conduct, meaning, oh, hey, we're all streamers. We're all streamers. Every streamer copies somebody. No. In fact, and if you look at the overall environment, streamers strike each other all the time. Streamers strike each other over petty stuff, over stuff that's clearly fair use. All the time. So it's not streamer culture to do this. Unclean hands. I love unclean hands. It sounds so good. Like, your hands are unclean. Go wash them. Go wash your hands, your dirty, unclean hands. So this one means someone has behaved badly in the specific situation they're suing about, so they cannot ask the court. So by asserting unclean hands, both Casey Tron and Denham's are saying that Ethan Klein did something naughty and therefore he can't sue. And I think what they're trying to say is him setting a copyright trap is unclean hands. The problem is it's not illegal or impermissible or dirty or not practical. Many people register their copyright. In fact, that's what you should do. In fact, you're encouraged to register your copyrighted material. So this seems like a very, very weak argument. I give it a 2 out of 10, and that's me being generous. And the likelihood of success being cope. Waiver. For waiver, what this says is the plaintiff waived a right relevant to their claim. So what right did Ethan Klein waive relevant to the claim? He hasn't waived anything. He hasn't waived anything at all. In fact, he's reserved all of his rights. So by arguing waiver, Casey and Denham's and their lawyer are just making this up. I don't see where this is coming from at all. So I say, once again, this is a cope. Estoppel. Now, this one, I think it's arguable, but not likely. It's weaker than implied license. It's probably, it's probably not a 4.5. It's probably like a 3.5. But estoppel is a concept which prevents a plaintiff from asserting a legal claim that contradicts their prior actions or statements, particularly if it would be unfair to the defendant. So it's sort of like an implied license. You could say, okay, because of the conduct of Ethan Klein in the past and the implied license, there's sort of like an estoppel here that should come out. I still think it's unlikely. 20% would be very generous. 20-30% would be generous with this one. So I think this one, yes, you can argue it. Yes, it's better than it's a hell of a lot better than Waiver. I mean, Waiver's a joke. Waiver's embarrassing. Waiver is like, what are you doing here? But Estoppel, okay, I see it. It's not going to win. But once again, remember, guys, even with really crappy clients, and I trust me, guys, Denims and Casey Tron clients, they're very bad clients. I would never want them as clients. Never. You still have to try. And if they tell you to throw the kitchen sink in them, you do that. Okay, this is a funny one. Justification and excuse. So defendant, that is Casey Tron and Denims, are saying that they admit to committing the crime, but they argue that the circumstances justify or excuse their action. Giving this a 3 out of 10 was really because I looked through the entire thing and I give them so many 1s and 0s. I had to try to give them some 3s because I wanted to be fair. But what is the justification? Because Ethan Klein is a bad human being, because he's a Yahtzee? The law doesn't apply differently to people because you think they're a bad human being subjectively. So I don't know what justification or excuse they have for copying it. Maybe they want to try to argue implied license or estoppel, and justification or excuse is a part of that. But I just don't see it as being a winning argument. I see it as sub 10% chance here. So this was a pity 3. It really should be a 2. Honestly, it should be a 2. But I gave it a pity 3. Okay, consent. This is sort of like implied license as well. So they admit that the infringement was committed, but assert there are additional facts that justify or excuse the action. So once again, just kind of sort of like justification, and otherwise negate the plaintiff's claim. Did Ethan Klein consent to it through implication? Maybe. I think 10-15% chance at most. Likelihood of success, very, very low. And the argument, very weak. Innocent infringement. Oh, it's cute. It's an innocent infringement. It's a cute infringement. It's a type of infringement you can bring home to grandma, right? Right? No. Innocent infringement. It actually, in a weird way, I give it a 4 out of 10 because it's not actually a full defense. So what innocent infringement is it means it can reduce the damages that the court awards on a copyright infringement case. It is not a complete defense to liability. I think this one is plausible because they could take some sympathy or pity on them and reduce the damages. That is possible. The judge can do that. So they could say, okay, it is infringement, but it's relatively innocent. So let's reduce the damages and not have them totally high. So I think it's arguable. I think it's unlikely to make the damages 0, but I think it's arguable. It is arguable. So I'm okay with that. Inequitable conduct. So there is a defense in patent law. Remember, this is copyright law. Copyright law is not patent law. Okay? So their lawyer is literally using an argument from patent law, saying that a patent applicant misrepresents or omits material information with the intent to deceive the Patent and Trademark Office. This is literally a non-existent argument, which is impossible, which only applies for patents, not copyright. This is the dumbest thing that I've seen in a while, where a lawyer is going to argue law from an area that we're not even talking about. And he does it multiple times. This is one time. He does it another time too, which is like, it blows my mind. Maybe he's trying to make a unique argument and saying, even though this exists in patent law, you judge, I want you in this case to make this up. But what doesn't make any sense is this usually only applies to the patent office. So what are you saying? They deceived the copyright office? I don't think so. And it's properly registered. So what proof do you have of that? That's what's funny there. Okay, unjust enrichment. One party was unfairly benefited at the expense of another party without proper compensation. This is hilarious because the only people that were unfairly benefited were the orbiters, were Casey, Tron, and Denims, right? The only people who unfairly made money were the orbiters. It was not Ethan Klein. How did Ethan Klein unfairly benefit? It makes no sense whatsoever. Where did his money come? Where did any money come from him? He didn't make anything. This is maximum copium. Saying that Ethan Klein was unjustly enriched. What are you talking about? Laches. The defendant can argue the plaintiff waited too long to sue and that the delay unfairly harms the defendant. This one is another one that is so brain dead. This is completely brain dead. It's near impossible. I give it a 0.5. I wanted to give it a 0, but technically you can make this argument. It's not illegal, but this is what they're arguing, guys. They are arguing that Ethan waited too long to sue. Ladies and gentlemen, he literally sued immediately. He literally sued like days after their videos dropped. You cannot possibly sue faster than he did. He had everything lined up and planned, like everything. And he sued me. And they're trying to argue he waited too long. That's their argument. It's fully within the statute of limitations. Like fully within the statute of limitations. This argument, it's like you're clearly just throwing this out there, which once again, I need to make it as clear. The lawyer is not doing anything illegal. He is entitled to make these defenses. But I'm also entitled to tell you that these defenses are absolute doggy doo-doo. Because they are doggy doo-doo. A big steaming pile. Not just a little Chihuahua pile. It's a Great Dane sized pile of doggy doogie. So let's just continue to sniff this mess, if you will. Failure to register copyright. This one I had to put at a 0. So they make the affirmative defense that while registration isn't required for copyright protection to exist, it's necessary to file a lawsuit for infringement. This is another argument that is brain dead because literally in the complaint itself, they show how they registered it and they give proof of registration. It is literally impossible. The copyright was clearly registered properly. It was done by a lawyer. It was done in the proper way. There is no way this argument wins. It's a 0 because it's properly registered. You have all the proof of proper registration. So once again, I think he just copy pasted a list or just threw everything at the wall, but this is going to be absolutely blown out of the water. So lack of notice. Defendants were unaware and could not have known about the lawsuit. Therefore, it should not be held liable. This is one I wanted to give another 0 as well. How are you going to be answering a lawsuit? So you've already answered the lawsuit and you're saying you have no notice? What are you talking about? You know the lawsuit's happening and you have notice, proper notice, etc. You had notice of the copyright, etc. So where's this lack of notice coming from? I don't understand this one. Complete cope. And typically, this is another one that lack of notice is typically only used for premises liability. So for example, this one typically works. For example, if you walk onto somebody's property and they have an alligator pit and they fall in the alligator pit. So if I, as a Florida man, right, if I build in my Florida man house, in Kissimmee, right, I build an alligator pit and I hide it under some leaves and you fall in the alligator pit and I didn't tell you there's an alligator pit, but I invited you over. You'd say, hey, I had lack of notice, right? I had no idea that was there. Or if there's something I should have told you about, right? For example, let's say I had a bunch of plants that were really made of super brittle glass that if you touch the plant, they would shatter in a million pieces. And you touch the plant, it shatters and I sue you. And you could say, well, I have lack of notice. You should have notified me not to touch the plant. So let's continue with the rest of the defenses here. Oh, wait, sorry. We got to the end. So lack of notice, not going to happen. It's cope. Failure to register, cope, impossible. Laches, cope. Unjust enrichment, cope. Inequitable conduct, impossible. Good faith, cope. No injuries or damage, cope. Innocent infringement, unlikely. Consent, unlikely. Justification, excuse, unlikely. Estoppel, unlikely. Waiver, cope. Unclean hands, cope. Implied license, unlikely. Express license, unlikely. Fair use, the only toss-up. And failure to state a claim of cope. You can see without a doubt, objectively, as I go through that, it is mostly cope. It is mostly cope. We are not in a situation where this is something that I would say, okay, this is something where it's going to be a reasonable argument other than fair use. I think they got to stick to fair use as their core defense and focus on that. All the time on this other stuff, really not worth it.